What is the estate tax? How does it work? How do we plan for it? I'm Freeman Green with Freeman Green Law, and we're going to look at the estate tax. Let's go. So, first, what is the estate tax? The way that this works is that when you die, the government says that we need to total up the value of everything that you owned on the date of death, including the death benefit on life insurance. Yes, including the death benefit on life insurance. Folks are used to thinking that life insurance is not subject to tax, but that's usually income tax. The death benefit on life insurance in general is subject to estate tax. So the way the estate tax works, we total up all the assets that you owned on the date of death. We subtract out liabilities, and then there's a percentage tax that you pay on the net value of the assets that you owned. So there's some rules though that modify that. Let's talk about those rules. We're going to make you estate tax experts. So, our estate tax rules, first rule has to do with folks that are married. And that is, anything that you inherit from a spouse is not subject to estate tax, as long as the spouse that's inheriting is a U.S. citizen. That rule seems generous, but it's actually kind of tricky, and we'll talk about that in just a little bit. Second rule is that you have an exemption. Your exemption is like your coupon. It's the amount that you can pass free of estate tax, and it's only amounts that are over the exemption that are subject to tax. So, first, there is a federal exemption. The federal exemption currently is just a little over 12 million. The federal exemption is indexed for inflation, and it tends to go up a little bit each year. In 2025, it's scheduled to drop in half, and depending on who gets elected in the next election and what politicians decide to do, you'll see this figure go up and down. Usually, it does not go much lower than, say, 3.5 million. Federal exemption, currently, if you go over the $12 million amount, you'll get hit with tax at a rate of 40%. Then, we need to consider state estate tax. And here in Oregon, we have a state estate tax. Oregon's state estate tax impacts estates that reach $1 million in value. If you go over the million, then you'll get hit with tax at a rate of anywhere from 10% up to as high as 16%. So, here in the exemptions, there's a planning opportunity. And let's talk about how that works. First, I want to be very clear. This planning opportunity, this is something that we do for married couples. And let me show you how it works. First, let me show you what it looks like if we have not done any special estate tax planning. So in that case, our planning would typically look something like this. Husband's estate plan says, I leave everything to my wife. Wife's estate plan says, I leave everything to the kids. And wife's estate plan would say the same thing, just in reverse. This is a very simple estate plan. This is what we call the I love you plan. If we look at this from an estate tax perspective, here's what happens. First, husband dies, leaves everything to spouse. When that happens, how much tax are we going to pay? we will pay no estate tax because of rule number 1. Then, when the surviving spouse passes away and things pass to the kids or to the beneficiaries, how much tax will we pay? Or another way I like to ask the question is, how much will pass free of estate tax? $1 million will pass free of estate tax. And so if you stop and you think about that, we thought this rule was very generous. But really what happened was, when the first spouse died and left everything to the surviving spouse, it's like they wasted their exemption. They wasted their coupon. Because then all of the assets and all of the value combined under the surviving spouse, and then at their death, they just have their $1 million coupon to pass assets on to the kids free of estate tax. So, in other words, it's kind of like the first spouse to die wasted their $1 million coupon. Is there a way that we can use both $1 million coupons? The answer is yes, there is a way. And I'm going to oversimplify this a little bit, but from a big picture perspective, this is how the planning works. The first spouse to die, instead of leaving everything directly to the surviving spouse, they say in their estate plan, I leave everything to a trust. With my spouse as the trustee. And you can say that the spouse is the trustee. You can pick a different trustee if you choose to. But oftentimes, folks will say that the surviving spouse is the trustee and that they are the sole beneficiary of this trust. And that gives them a high level of control over the assets. This trust gets its own tax ID number. It's like its own entity. And there would need to be a separate income tax return filed for that trust each year. That only comes into play after the first spouse has died, though. And what happens here is that the surviving spouse, they have control of these assets. They're able to use them to live on and to pay bills. But we can take and we can make an election on this trust, and we can say that for estate tax purposes, up to $1 million of what has gone into this trust, in the future, when it passes on to the kids, will not be subject to estate tax. In other words, that's going to help keep some or all of the first spouse to die's $1 million coupon alive. And here's an interesting thing. If the property that's put into that little tax-free bucket, if it increases in value, the increase in value can also pass to the kids free of estate tax. So if you had a piece of land in there and the land goes up in value, the increase in value would also pass free of estate tax. So with this type of planning, you can keep some or all of the first spouse to die's coupon alive, and then the surviving spouse continues to have their $1 million coupon to pass assets free of estate tax. And you could pass $2 million free of estate tax, potentially, using this type of planning. And you'll hear this go by many different names. Sometimes folks call this disclaimer planning. Sometimes they call it a credit shelter trust. They will call this a bypass trust. Sometimes you'll hear it called a B trust. Many different names referring to this general approach of planning. And there's different ways that this little bucket can be set up depending on the circumstances. Sometimes we draft in the documents that this will spring out of the will or spring out of the trust when the first spouse dies. Sometimes we say that it might spring out and come to life if the surviving spouse chooses to have it come to life. Exactly what you choose is very specific based on circumstances and wishes. So, exemptions, one of the key things is to make sure that both spouses use their exemption as much as possible. And in a state like Oregon, to do that, you want to make sure that the documents have the correct planning provisions. Then, another thing to look at for saving estate tax is gifting. We could do a whole session just on gifting. But just to summarize, if you give something away before you die, then you don't own it to be taxed at your death. The federal government has a law in place that limits that for federal purposes, but Oregon does not. And so one of the most powerful ways to reduce or even eliminate estate tax in Oregon is to make gifts during life to reduce the value of your estate. If you want to make gifts and you are alive and able, then you just make gifts. But if you become mentally incapacitated, gifts can only be made if the proper gifting provisions have been built into your power of attorney and your trust, if you have a trust. And that is a really good thing to have if you're concerned about the estate tax. Oftentimes, where gifting provisions get used is in a situation where somebody's been put on hospice and they've lost mental capacity. We know that they're going to pass away in the near future. When that is the case, that can be a good time to do some what we call deathbed gifting. And we can identify assets that would be good assets to gift, and then the trustee or the agent on the power of attorney can use the provisions of the document to do some gifting. And it's like passing down the inheritance a little bit early and saving estate tax in the process. Another good thing to be aware of is that anything you leave to charity in your will or in your trust or using a beneficiary designation will not be subject to estate tax at your death. So if you were to leave everything to charity, you would not pay estate tax on that as a general rule. So that's the estate tax. We talked about the federal estate tax briefly and the Oregon estate tax. One thing to keep in mind about the Oregon estate tax is that that $1 million is not indexed for inflation. It has been at $1 million for some time, and it looks like it will continue to stay at $1 million for the foreseeable future. And that's the estate tax. Thank you for watching. I hope that was helpful to you. If you think that video might be helpful to someone else, please feel free to share it with them. And if you think that our law office might be able to help you with trusts, probate, or estate planning, please feel free to contact us. Thank you.